Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. This will be a video for the hometown crowd. Washington, we need to have a talk because, as you know, we are in the middle of a legislative session. And what I did this year, a little different than what I've done the last 2 years, is I didn't really talk about a lot of pieces of legislation other than to give you guys a thumbnail sketch until I could really see which ones might actually have a chance of passing out of the legislature and making it to the governor's desk. We're going to talk about exactly one of those pieces of legislation. In fact, candidly, of all the pieces of legislation in Washington state that actually has a chance of becoming law, this is the one that absolutely has me freaked out the most. If you are in the FFL industry, you are absolutely crapping yourself over it. And if you don't know anything about it yet, shame on you. But we're going to get you educated today because this is one of the most important bills that we need to fight about in a long time. So today, let's slow it all down. Let's get you guys to understand what's going on here. And let's talk about how Washington state will destroy the FFL industry. Okay, Washington, this is what we're talking about today. We are talking about House Bill 2118, a piece of legislation sponsored by Liz Berry, so you know where we're going with this. The preamble reads, an act relating to protecting the public from gun violence by establishing additional requirements for the business operations of licensed firearms dealers, amending RCW 9.41.110, and providing an effective date. Now, what this really should be called is how can we put every single FFL in Washington state out of business? Because if this bill becomes legislation, if it actually becomes law, it has the potential to do exactly that. I will guarantee you, all of your small mom-and-pop independent stores out in rural parts of Washington state, Southwest Washington, Eastern Washington, all those other places that are relying not on the Cabela's, not on the Bass Pro Shops of the world, but actually independently owned FFLs, yeah, you are going to be sunk because there is no way, and listen to me carefully, there is no way that your FFL will be able to comply with this legislation. Why? Because it's designed so they cannot comply with this legislation, because this will place expenses onto the FFL's operation as far as retrofitting their building, as far as completely redesigning the way they do business just to be in compliance with this law, that it will be cost prohibitive and they will be forced to shut down. I'm going to go through the bill in kind of a rapid fire fashion so that you can understand all of the things that are in this bill. Now, on a side note, this legislation has already been enacted into law in California. Shocker, I know it, Liz Berry, cutting and pasting from California. It's called California Penal Code 26806. It is the subject of a huge lawsuit, and it is the subject of this video right here. Now, let me just start going through the bill as fast as I can so we don't have a 30-minute video here so you can understand everything that every single gun store will have to do, and then we'll point out what is even the most offensive thing that doesn't jump right off the page at you here. Okay, all new sections added to 9.41.110 governing how FFLs conduct business. The new language would read as follows. The business building location designated in the license shall be secured, 1, with at least one of the following features designed to prevent unauthorized entry, which must be installed on each exterior door and window of the place of business. A, bars or grates, B, security screens, or C, commercial grade metal doors, and 2, with a security alarm system that is A, properly installed and maintained in good condition, B, monitored by a remote central station that can contact law enforcement in the event of an alarm, C, capable of real-time monitoring of all exterior doors and windows in all areas where firearms are stored, and D, equipped with, at minimum, detectors that can perceive entry, motion, and sound. Now, again, I'm not saying that any of these are bad ideas, but what this legislation does is it forces all of these security measures onto every single FFL, regardless of what their physical structure currently looks like. Now, there are a lot of FFLs that will be in compliance with some of this. There are other FFLs, of course, that because of where they operate, the type of building they're operating in, they're going to have to change and retrofit their building. But as you get further into this legislation, you'll see that, don't worry, it doesn't matter, because even the big box stores, even the Cabela's and the Bass Pro Shops are going to get smoked by this legislation. Now, changes in the way you're going to have to operate during business hours, because the legislation then would mandate dealers shall secure each firearm during business hours except when the firearm is being shown to a customer, repaired or otherwise worked on, in a manner that prevents a customer or other member of the public from accessing or using the firearm, which may include keeping all firearms in locked containers or in a locked display case. And again, for some dealers who have firearms on display on the walls, predominantly long guns, yep, that practice comes to an end. So now you're having to retrofit all of your interior walls. There's more, including how you have to conduct business when you're not open for business. Other than during business hours, all firearms shall be secure in a locked fireproof safe or vault on the dealer's business premises or in a second and locked area in the business location designated in the license. A locked display case is not sufficient to satisfy this requirement, which means that theoretically you're going to have to keep an employee there after hours and move all of the inventory into some sort of an internal safe if you even have the square footage to do so. Because locking it up in the building and locking it up in the case, that's not good enough for Liz Berry. But if you really want to see the George Orwellian dystopian nature of this bill, and where a huge, and I do mean huge, amount of cost gets run up, check out the mandatory video recording requirements now. A dealer shall ensure that its business location designated in the license is monitored by a digital video surveillance system that meets all of the following requirements. 1. The system shall clearly record images, and for systems located inside the premises, audio of the area under surveillance. 2. Each camera shall be permanently mounted in a fixed location. Cameras shall be placed in locations that allow the camera to clearly record activity occurring in all areas described in Section A3 of this subsection and reasonably produce recordings that allow for clear identification of any person. Okay, you got all of that now? Now, what portions of the building needs to be recorded? Check this out. The areas recorded shall include, but are not limited to, all of the following. A. Interior views of all exterior doors, windows, and any other entries or exits to the premises. B. All areas where firearms are displayed. And C. All points of sale sufficient to identify the parties involved in the transaction. And then I want you to pay attention to what the requirements are, because this is where every single FFL is going to get smoked. The system shall continuously record 24 hours per day at a frame rate of no less than 15 frames per second. The media or device on which recordings are stored shall be secured in a manner to protect the recordings from tampering, unauthorized access, or use or theft. Recordings shall be maintained for a minimum of 6 years. Now, I've already had some geeks looking into this, so I just want you to know, if you have multiple cameras recording 24 hours a day, 7 days a week, 365 days a year, at 15 frames per second, and you got to store all of that video going back 6 years, you are talking about a server the size of what Amazon is using, okay? We're talking about a server that's going to run somewhere between $150,000 and $200,000, and it's the type of server that you probably have to retrofit your building just for the server to function inside of that building. And then, if all of that is not enough, the state also is going to mandate that FFLs put up signs that only tell a half-truth but will clearly have a chilling effect on business. Let me explain what the sign says. These premises are under video and audio surveillance. Your image and conversation may be recorded. Now, shockingly, some people just don't like to have themselves recorded, but the wording of this sign is mandated by statute makes it appear as though it is the FFL's choice to record you in this fashion. The sign should properly read that by order of the state of Washington, these premises are under video and audio surveillance. Now, the legislation also goes on and mandates all sorts of record keeping, but of course Liz Berry doesn't know what the hell she's talking about, so almost all of that record keeping is already maintained by FFLs because it's required in order to maintain their license. Good work, Liz. The other thing is every single FFL will be required to have at least a $1 million liability policy. Now, I've had an opportunity to geek out with a lot of FFLs, some very reputable ones, guys like Tom up at Security Gun Club, Dan Mitchell down at Sporting Systems. Listen, they're pricing this thing out and they're looking at $150,000 to $200,000 plus just for the server alone. You are looking at a $500,000 investment in many properties in order to actually stay compliant with this law. This piece of legislation, if it enacted into law, is literally going to destroy almost every single brick and mortar FFL in the state of Washington. But here's the big coup de grace, because you probably haven't caught that, because it's not listed in the statute and there is no exception. But let us remember that home-based FFLs probably outnumber your retail operation FFLs in this state, nationwide for that matter, approximately 7-1. So if you had 200 FFLs in the state, you'd have roughly about 1,400 home-based FFLs. Is there any exception in this legislation for home-based FFLs? No, there is not. Which means that this is a piece of legislation that Representative Liz Berry is sponsoring that would mandate 24-hour, 7-day a week, 365 days a year video surveillance inside a person's own home based upon the profession they have choosing. Folks, this is House Bill 2118. It is absolutely one of the most atrocious pieces of legislation to come through Washington State in a long time, and that is saying something. We need all of you to get on the horn right now with your legislators, whether in the House or the Senate, and tell them that this bill absolutely, positively has to be killed. We're going to go ahead and link up everything down below so you can geek out on it for yourself. We're going to go ahead and link up the Conservative Ladies of Washington's Legislative Action Center so you can always stay up to date on all the insanity in Olympia. Now, if you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it is also down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.